suggestion of consular access not being granted in cases of espionage because of national security concerns. During its 1961 session, the Commission decided to change the words "without delay" to "without undue delay." The Court observes that this decision had no implication for the scope of draft Article 36. The Commission's commentary to draft Article 36, paragraph 1b, merely states that, and I quote, "the expression without undue delay used in paragraph 1b allows for cases where it is necessary to hold a person incommunicado for a certain period for the purposes of the criminal investigation," end of quote. During the United Nations Conference on Consular Relations held in Vienna from 4 March to 22 April 1963, the question of espionage was raised in relation to the words "without undue delay" in draft Article 36. The chairman invited Mr. Zurek, the former special rapporteur of the International Law Commission on this topic, to explain why the International Law Commission had included the words "without undue delay" in its draft. The explanation given by Mr. Zurek suggests that while the charge of espionage was thought to be relevant in determining the appropriate period of time within which notification to the sending state should be made by the receiving state, cases of espionage were not excluded from the scope of the Vienna Convention. The Court further noticed that in the course of the discussion on proposed amendments to draft Article 36, including a proposal by the United Kingdom to delete the word "undue" from the phrase "without undue delay," which was eventually adopted, it was not suggested that certain categories of persons, such as those suspected of espionage, were to be excluded from the protection of the Convention. The travaux préparatoires thus confirm the interpretation that Article 36 does not exclude from its scope certain categories of persons, such as those suspected of espionage. Turning now to Pakistan's second argument regarding the existence of an alleged espionage exception under customary international law, the Court noticed that the preamble of the Vienna Convention states that the rules of customary international law continue to govern matters not expressly regulated by the provisions of the present Convention. Article 36 of the Convention expressly regulates the question of consular access to and communication with nationals of the sending state and makes no exception with regard to cases of espionage. The Court recalls that India and Pakistan have been parties to the Vienna Convention since 1977 and 1969, respectively, and that neither party attached any reservation or declaration to the provisions of the Convention. The Court therefore considers that Article 36 of the Convention, and not customary international law, governs the matter at hand in the relations between the parties. Having reached this conclusion,